Here we are again, and I'm delighted to give the floor to Professor Diane Ring, who serves as the Interim Dean of Faculty, Professor of Law, and Dr. Thomas Kearney, Distinguished Scholar at Boston College Law. And Professor Diane Ring will chair a panel entitled Identifying the Interrelations Between Corrupt Practices and Tax Abuses, Lessons from Beyond Europe. Dear Diane, the floor is yours.
Thank you very much, Costa. So for this panel, I'm delighted to introduce our three presenters. And really, this is our chance now to begin to move beyond the more intensive focus on the EU and look at these issues of both sort of corruption and taxation as we move beyond. So first of our three presenters, Sarah Poppy Alexander. She's a partner at Constantine Cannon's San Francisco office. She represents whistleblowers and government entities in qui tam lawsuits in both federal and state court, as well as under the Internal Revenue Service and the Securities and Exchange Commission's whistleblower programs. Poppy graduated from Harvard Law School, where she was co-editor in chief of the Harvard Civil Rights Law Review, and an active member of the Harvard Human Rights Clinic. Poppy holds an MA in political theory from the University of California, Berkeley, and a BA from Yale College. Our second presenter is Professor Benja Satella. He serves as Vice Rector at the Catholic University of Angola for Scientific Research and University Extension. He holds a law degree from the Catholic University of Angola, a postgraduate degree in corporate criminal law from the Portuguese Catholic University, and a master in legal and criminal sciences from the Portuguese Catholic University. He is a lecturer and director of the Law Research Center at the Catholic University of Angola and a lawyer. His work includes, among other topics, a focus on compliance and money laundering and sustainable development. And our third presenter for this session, Dr. Sarah Carrick. She is currently a lecturer at the Manchester Metropolitan University, and her research interests range from sports and intellectual property law to tax law. Having completed her LLB at the University of Stirling, Scotland, she continued her studies there, completed her PhD in 2019. And her research explores the relationship between athlete image rights and tax avoidance, which remains a key part of her research and teachings today. So I want to make sure we maximize our time for our presenters and some conversation after. So 10 minutes each. Poppy, I will turn it over to you.
Hi, everyone. Thanks so much for being here today, and thanks for inviting me to represent the U.S. perspective, which is, an extremely small category. So to that end, I really want to focus on some recent changes that have been happening in the U.S. and some recent legislative proposals, some of which have passed, some of which have not. And some of where we think we might be going, or where at least we hope we might be going, trying to curb the movement of dirty money. So I'd actually like to start with something that was proposed last fall that has not actually passed, but the reason I'm starting with it is because I think it could lead to some of the biggest changes that we've seen recently in the US, and that's a law called the Enablers Act, which was proposed back in October of 2021 in truly direct response to the Pandora Papers, the release of all the information about all the different ways that people were moving their money out of the US to hide it, and to therefore avoid US tax obligations, among other potential criminal actions. And the reason the Enablers Act is so powerful is it would expand what's existing law of the Bank Secrecy Act to include a whole bunch more actors. So what is the Bank Secrecy Act? The Bank Secrecy Act is sort of secretly the US's main tool to try to curb dirty money. And the reason for that is it sets out the sort of basic compliance obligations of any bank or money transmitter, as well as a few other actors that you might not immediately think of. For example, a lot of crypto exchanges are probably within the definition of money services businesses and therefore within the BSA. And it requires them to do sort of basic know your customer checks, as well as verify source of funds. And it obligates banks and these other money services businesses to file SARs or suspicious activity reports whenever something goes wrong or whenever something looks weird. So the Enablers Act proposed expanding the BSA to include a whole bunch more actors, all the people who help rich people move their money somewhere else, essentially. And those are people like me, lawyers, accountants, art dealers, and sort of critically investment advisors, who might not be someone you might immediately think of, but are sort of currently fall through this hole in the BSA. So this would be an extraordinarily powerful tool because this would suddenly impose all these compliance obligations on people who thus far have been able to sort of avoid that. The law sat and was stalled, but has started to once again gain some additional traction in light of the Russian invasion of Ukraine, which has really thrown a huge spotlight on the movement of dirty money, here and elsewhere, of course. So the Enablers Act is really also then building on two major changes that have happened within the last year. One of which is the Corporate Transparency Act, and the other is the FinCEN whistleblower program. So the Corporate Transparency Act, or is also known as sort of the Sunshine Law, requires various LLCs and other sort of secret companies to release basic ultimate beneficial owner information to banks and to law enforcement. This is not going as far as a lot of other jurisdictions have gone, but it's something, and it's an important something, particularly for famous US secrecy jurisdictions like Delaware, Nevada, etc. So it ends total corporate secrecy, but it does not release this information to the public. Which of course is really difficult when we're talking about trying to hold people accountable, because we aren't then able, you or I aren't then able to sort of trace ultimate owners of the LLCs, but it certainly is a step in the right direction. Another major change that happened at the same time as the Corporate Transparency Act and was part of this whole sort of package of bills related to improving financial secrecy legislation in the US, was the creation of a new whistleblower program at FinCEN. And I'm a whistleblower attorney, so obviously I'm prejudiced, but I truly think that this is the most important change that we've had recently, because what we've done is we have created a program for whistleblowers to come forward and tell law enforcement when they know of violations of the Bank Secrecy Act. And right now, the FinCEN whistleblower program is limited to violations of the Bank Secrecy Act. So this does create sort of a formal process where whistleblowers can report when they know that a bank or another agency or another covered entity is violating the BSA. This law is about to become a lot more powerful because as of yesterday, we just got a new proposal that passed out of committee and is now going to the House floor. And we have very good reason to think that it will in fact pass Congress to expand the law to include sanctions violations within the FinCEN whistleblower program. So suddenly someone with information related to an entity that is violating sanctions, and obviously the sort of congressional focus right now is on Russian oligarchs who are hiding their money in US real estate. But it applies more generally to anyone in violation of sanctions. We'll be able to bring that information to FinCEN, and we'll have a formal process for doing so. And we'll have the whistleblower protections that come along with that, including potentially receiving a reward at the end for coming forward and being willing to take that risk. So this is a huge change and a huge expansion of the law, and we'll see what happens. But we do think that there's a very good chance that this is going to pass. So this is, one more sign that we are seeing some fundamental change in the US, and that we are seeing some sort of expansion of the tools that we have to try to control dirty money. That said, this isn't everything, and the BSA remains very limited. And until we get the Enablers Act passed, it's going to continue to be very limited. So that continues to be a challenge in the way that we've put together our regulatory universe. There are a lot of other challenges, obviously, and I don't want to paint an overly rosy picture of where we're at right now. A big one is, as I mentioned, this sort of loophole that we have right now for investment advisors, which also then puts us in trouble with things like private equity and other sort of private, less regulated market players, where it's not that hard for people looking to hide their money to do so in via investment advisors who are not covered by the BSA and are also sort of can fall into this regulatory loophole and hole. At the same time, we have a growing use of trusts, and we have growing use of trusts in jurisdictions such as South Dakota, which is very actively recruiting people to come to create secrecy trusts, which then are used to move money offshore, and then sometimes bringing it back onshore via investments in private equity, but doing so via their offshore entity. And you can see immediately how that is problematic, and how people are avoiding US taxes through these sort of loophole after loophole series. There's also just sort of continued issues, which is always true in the US, of our mixed jurisdictional rules. We have too many different regulators with some jurisdiction over some part of these issues, and no one with overall oversight. And sometimes that works well, but oftentimes that means that people can slip through the cracks. And that continues to be a problem. And we haven't really seen a solution to that coming forward or being presented yet. And then, I want to close with one sort of fundamental problem, which is, in the US at least, there are so many tax avoidance schemes that are not illegal and that are perfectly legal. And there have been no proposals and no solutions to try to get at those issues. And here the journalist agency ProPublica has done an extraordinary job of publishing a lot of information about all the various ways that extremely rich Americans are able to avoid taxes, not violating any laws at all. And we have not seen any movement thus far in how to fix that. And until we do, in some ways, cutting at the illegal schemes is only just sort of cutting around the edges. So that continues to be a challenge, and hopefully we will see some movement there at some point.
Great. Thank you so much, Poppy. All right, now I'd like to turn to Professor Benja Satella to start his presentation. So I'll turn it over to you, Benja.
Thank you, Dan. Good afternoon all. I will share. So I want to say I'm from Angola. Angola is a sub-Saharan African country. And Angola is a controversial country because in one side, we are rich in resource, but another side, majority of the population is poor. And in this coexistence between poverty and unemployed people, what VAT was implemented. VAT became and joined to another group of taxes that already exist, which increase the cost of living of the population. To say, in Angola, 49% of the people is poor, 70% of the economy is informal, and 32% of the people is unemployment. In this cocktail, poverty versus empowerment, the VAT regime was implemented. According to our social and economic report, the price when the VAT was implemented, the price increase of all products, including the basic food basket, and it is new taxes become. We have a new legislation, criminal legislation. Our code, tax code, general tax code, have maybe 23 main type of the crimes, but the value, the tax, the law of the VAT didn't have a criminal types. So we found in the criminal code, our criminal code, main of the crime we apply in the VAT. So the corruption, passive and economic corruption, they are, and active and passive corruption for public offices is in criminal code, where is in this situation. The implementation of economy is the phase of number of conflict of the interest, the fraud, influence, spending, the exploration, the vulnerability by those involved in the process, because we have in the tax form, we have control of the player tax by the tax administration is limited. He is dependent of cooperation of the tax itself. The tax administration was very strong human element, susceptible to begin corrupted, scraping off sympathies which the founding taxpayer do, kingship or friendship. So we have main insufficiency and deficient knowledge about tax legislation. The people is very poor. The 30% of the economy, formal economy, is on the people pay the tax. The insufficiency of the control of activity relative of company, the increase of the tax burden of the same tax subjects, the escalation of the price of acquisition in the formal system maybe precipitate the consumer to consume in the informal economy, where the prices are competitive low, and without the tax, including without the VAT. We have the fact in Angola, we have some culture. The people know that, the people think that when some people go to the public office, this is the passport to enrichment themselves. So, and these people, the fact, control the national tax system, or the national tax system, and the illicit and criminal conduct, tax fraud, undue receival of advantage, active and passive corruption, abuse of tax tasks, and illegal collection of contribution are among of the crime were most commonly committed in Angola. So we have main challenge, we have a huge challenge about this, because we need to training the agent working in the tax administration, include training the matter of the ethic and integrity. We need to increase the people tax literacy, social program and tax awareness, to improve our legislation, avoiding excessive gray area, because we have very excessive gray area. Enforcement, the obligation to use technology solution, we didn't have because the people have main intervention of human action. And we need to open hours increasingly remote and automatically inspection. So it is in this situation, in this context, where the tax, the VAT is implemented, and we have the corruption, but we have the public office control all the tax system, also the tax of the administration system, and we need to, the judge and the prosecute didn't have more practice about judgment or control of the tax crime, because the VAT was come in force in 2020 and past 2020, and we looking how the best way to control and to combat all the crime in the tax system. So in Angola we have main taxes, maybe 7 or 8 different type of the taxes. And this is the way to fraud, to corruption, and different matter of the crime. So we have in the criminal law more crime about fraud, taxes, and corruption, and we call this peculato. And when the people not fund in the tax legislation and crime, but we go to the criminal code, to criminal legislation to fund the crime and to apply in the conduct of the tax computation. This is a small picture I want to give in this conference about our system, our power system, because we have main challenge to strengthen this system. Thank you.
Thank you so much, Benja, for that. And I just kind of want to take a moment. You all saw a pop-up message from Costa, just encouraging you to put your questions in the Q&A function. And we're looking forward to sort of getting to that at the end of our presentations, but certainly pop them in now as you're thinking about them. All right, so that brings me to our third presenter in this session. So Dr. Sarah Carrick. Sarah, I'll turn it over to you.
Thank you very much. So what I want to talk about today is exploring tax avoidance in the context of athletes in both the UK and Canada. Sorry, that should be changing. There we go. So tax law is very clearly a grey area of law. And all too often we have companies, advisors sitting on that very fine line between tax avoidance and evasion. In the context of sports, this is particularly true, and sports stars are often creating headlines for possible tax evasions, and clubs have also been in the spotlight. The purpose of this presentation is to highlight the tax abuses in the UK in the context of sport, but also to illustrate that there are better ways of doing it by learning from the Canadian approach to taxing these high-earning athletes. Canada do it in a manner that's clear, transparent and predictable, and it ensures that tax avoidance sits firmly within the right side of the grey area rather than bordering on evasion and illegality as is done in the UK. So if we look at the UK first, athlete tax avoidance has sparked a lot of media controversy over the years. HMRC, the UK tax authority, have been considerably active in their pursuit of footballers. So in 2015, they launched the Football Compliance Project, which has already recovered around 369 million from the industry. Before the pandemic, they were investigating 330 footballers, 55 clubs and 80 agents. So it does show that it is a problem within this area. The issues in the UK generally all stem from image rights payments. So athlete endorsement earnings are all obviously very often worth a lot of money. So David Beckham earned £75 million in his first year of professional retirement. And Gucci have just paid Jack Grealish a seven-figure sum for his signature. The problem is not all athletes have the ability to attract these commercial endorsement deals, and yet clubs are still paying them for an image that isn't really worth anything in order to make a tax saving, which brings it to tax evasion. So what are the tax savings? Well, players will assign their image to an image rights company. They usually own that company themselves, and clubs enter into agreements with that company in order to exploit that player's image for a fee. This means when they pay that fee, the clubs don't have to pay national insurance because it's not a salary. So that's around 15% they're saving. Players don't get their 45% income tax or their 3% national insurance. Instead, what they have to pay is corporation tax, which sits at 19% rather than 45%. So there are a lot of tax savings in doing so. But the problem is, if there's no image right in UK law, then how do we value what someone's image is worth? So we don't have a statutory image right, and it's only really acknowledged in some HMRC guidance. So when celebrities have been protecting their image, they'd have to use traditional intellectual property remedies, such as passing off or breach of confidence, which wasn't designed to deal with this. There is a common misconception that footballers are gaming the system, and although in some cases this can be true, the system isn't fit for purpose. So we've no way of valuing what someone's image is worth. So there's no way of telling whether their payment for an image right deal is legitimate or not. So £1 million might be totally legitimate for Jack Grealish of Manchester City, but perhaps not for Chris Ayer of Brentford or Shane Duffy of Brighton. And that's the problem if these players have image rights deals and are making a tax saving based upon it when it isn't really worth anything in the first place. To add to the problem, the sports club case dates back to 2000, and it essentially gave the green light to image rights payments. So HMRC argued that these image rights payments for Dennis Bergkamp and David Platt of Arsenal were salary and not actually image rights. HMRC said that was an image rights payment because if commercial organisations were willing to pay the money for it, then they had independent value and they weren't a smokescreen for additional remuneration. The problem is that it essentially gave the green light to image rights payments, and during the 2000s, clubs entered into lots of these agreements with players that didn't really have an image worthy of this taxation benefit. So Hull City paid over £100,000 to Giovanni Gomez's image rights company. Now, no one knew who Gomez was. Hull didn't really have the resources to exploit their image, and his image had never been exploited in the first place. So this was held to be illegitimate. But so many clubs had done it, but with Sports Club, they essentially gave the green light to do this. What we have to acknowledge is the autonomy of sport versus the law. So sport generally is very autonomous, and the government, as well as sports governing bodies, are very reluctant for sport to be overly controlled by the law. If the law was rigidly applied to sport, then we couldn't have sport existing in the first place. So if the law of consent applied, we couldn't have contact sports. The same principles can perhaps explain why athlete taxation remains within this grey area of law, and it ultimately enables tax avoidance and evasion. We also have to consider here the role of tax advisors. It's an extremely complex areas of law, and athletes and clubs wouldn't be able to do this without the help of advisors. So you can argue that they act as enablers here. 98% of these high-earning athletes have tax advisors. The fact that they're rarely disciplined just reinforces the fact that the law is reluctant to intervene in sport matters, and that these advisors do play a prominent role in this tax avoidance. Ultimately, having an image right in one area of law and not the other is problematic. But this avoidance and evasion is facilitated or has been facilitated by the courts and advisors with no way or no clear mechanism to value an image. The key here that reform is required, and we have to take lessons from the Canadian approach. So if we look at the Canadian approach, we can look at ice, or I've used ice hockey here as an example, which plays a broadly comparable role to football in the UK. Their sports stars also earn considerable amounts of money from salary and from endorsements. Here, it's still taxable income, but the way in which they operate is clear, transparent, and predictable, which is ultimately the aim of any tax system. So with their image rights payments, athletes do not receive a percentage of their salary through image rights. It's all agreed through their collective bargaining agreements, which distributes image rights payments in respect of NHL events and promotions equally among players. They can go off and get their own outside those NHL promotions. Could be regarded as unfair to those who are more commercially attractive, but it does offer transparency and certainty. The bottom line in Canada is that athletes can avoid tax, but they do it in a legitimate manner in a statutory enforced framework. The justification for this is that they acknowledge the short-spanning nature of the athletic career. So an athlete might work for 10 years, whereas if you're a doctor or a lawyer, you might work for 40. The Canadian system offers 3 ways in which they can reduce the bill, which I'll quickly go through just now. The first one is a salary deferral arrangement. So that allows athletes to essentially defer a portion of their salary, which can be paid back to them in years to come when their gross income and therefore their tax liability is ultimately lower. They don't have any tax implication until the deferred payment is made. The problem with this is that they are essentially unsecured creditors of their employee club. So if the club reaches financial difficulty, they may not get their salary or deferred salary back. But it is a legitimate way of reducing their tax bill. The second way is an employee benefit plan. So the club will pay it to a trustee, they hold the funds for the athlete, and the athlete isn't subject to tax until those funds are distributed. They will get the yearly income and interest accumulated that will just be paid back and taxed accordingly. The only drawback is that clubs can't enjoy the tax deduction until the funds are withdrawn, so clubs might be less reluctant to enter into these plans with their employee. The last way they can do it is through a retirement compensation plan. So the employer and or the employee make contributions to a custodian who holds the funds in trust either until their ultimate retirement or the termination of the contract. They generally have another pension plan, but the athlete here isn't taxed until they receive the benefit, again at which time their gross income will be considerably lower, and all contributions are subject to a 50% reduction in tax. The only drawback here is, unlike the employee benefit plan, it's not an interest-bearing account. So all 3 mechanisms have advantages and disadvantages, but the bottom line here is that they provide a legitimate, transparent and predictable way of reducing an athlete's tax bill, unlike the UK. Of course, there's various moral considerations to think about, whether we should be allowing athletes to avoid tax in the first place when they earn so much money. But Canada, unlike the UK, makes sure that this tax avoidance sits firmly on the right side of that grey area, whilst the UK continues to battle between avoidance and evasion because they have such a convoluted, unpredictable system of tax, which just now is ultimately open to abuse. Thank you.
Great. So if you want to close out your screen, Sarah.
There you go.
Perfect. All right. Well, thank you, all three of you. I imagine that everyone sort of listening is thinking about how the sort of bit of a deep dive in the three different countries matches up with a lot of the issues we saw in the first two panels. And so what I thought I'm going to do is just start out by asking, I had a number of questions I wanted to go for each of the panelists. I would do that and then see additional time. And if we have questions, more questions that pop up in Q&A, I'll jump to those as well. But just to kind of go in order, Poppy, I'll start with you and two questions. So the first, and I'll just say them and then turn it over to you. The first is, you know, as you mentioned, the Enablers Act would really expand sort of SARS type reporting type obligations to a wider array of players in the field. And I was just curious your thoughts on that as a likely, assuming it passed, a likely successful avenue, given some of the critiques of sort of the SARS process already, right? And sort of the question of whether or not those who currently have obligations are really reporting in a way that's helpful, and whether the government's either following up or able to follow up in a way that's sufficiently meaningful. So that's a question of, is SARS the right path? Maybe it's just a best. And the second is where you ended, right? With the with a comment about the range of activities that are still effectively permissible. And sort of just to ask you to sort of offer your thoughts as to why that is. That is, are those the more valuable ones? And so everyone kind of is willing to get behind a little bit of enforcement. Think about, you know, the Corporate Transparency Act, but so long as they leave open the key paths for financial planning. So just your thoughts on both of those.
Well, I will try not to be too cynical on my answer to either of them. But you know, to your point about SARS, you're absolutely right, and this sort of points to a fundamental problem we have in the U.S., which is we have a disclosure regime. You know, as long as you disclose what you're doing, you can kind of do whatever you want, and that's a problem in the SEC enforcement, and that's a problem in SARS. And you know, you're off the hook as long as you tell the government about it. So how do we get around that? Well, there's a couple ways. One, I am actually more interested in the sort of pre-transaction part of the BSA. So things like the obligation to do know your customer work, to verify source of funds, to have a functional compliance program. Those are actually very powerful tools of the BSA that get sort of ignored because we focus on SARS, the sort of after transaction part. So that's one. I think that there's a lot of value there, particularly in the verifying source of funds. If companies are actually doing what they're supposed to do, that can be a real good tool. The second is we just need more funding to FinCEN. I mean, this is a general theme. The IRS and FinCEN are the two most underfunded agencies in the US, and that's insane. Like these are, you know, the IRS is the agency that is the only agency that creates revenue in the US. Why are we underfunding their enforcement arm? And FinCEN is the agency that this teeny little agency, we hold responsible for maintaining the integrity of how money moves through our system. These should be our most funded organizations, and instead we have just starved them for funds. So I think feeding money to both of those organizations needs to be a top priority, and I hope would solve a lot of the problems with SARS that we have certainly seen. But to your point about the legal loophole, I mean, it's very hard not to be very cynical about this. You know, these are the rich people who donate a lot of money to politicians and therefore have managed to maintain a legal system that allows them to avoid taxes, so they have money to continue donating money to politicians. It's a vicious cycle. I really hope that with continued efforts by journalists, you know, particularly ProPublica, the New York Times has done a lot of really good reporting on this, ICIJ, have really put an emphasis on the legal strategies people have to avoid taxes. And each time these reports come out, there really is some outcry. And the hope is that with continued public outcry, something will be done. Congress will realize, some of those loopholes I'm sure are on purpose. Some of them I think are accidental, and they just haven't thought about that particular little problem. So maybe there's some hope there. And the legislative trend in the last couple of years is good for this, and I hope that continues.
That's a positive way actually to frame. If you think about a trend, right? You don't get it all at once. I also think it sort of helps to think about where we saw in the first two panels sort of a number of times asking the question, what do we mean when we're talking about sort of corruption and taxation, and taking the broad view allows us to sort of have more of the public conversation about those things that are currently legal in some way. But honestly, if you saw them and you looked at them, you'd say, really, should they be? And that may be a way of kind of, if you think about sort of the incremental sort of mind shift that perhaps, journalism and public disclosure of their research may have. So we'll see. But I will try to be optimistic. Thank you. Benja, I want to turn to you next, and I was really struck by how a number of the points that you raised really reflected, particularly some of the ideas that came out of the first panel. And I was thinking about, but what is the relationship between the tax system and the criminal law system, and where do tax crimes sort of sit? Are they inside tax, or are they really part of the general criminal law? And also, several points, really, your remarks touching upon the importance of the public perception of the tax system and how that plays into both taxpayer behavior and that of the officials as well. So that was sort of a backdrop. The two questions that I wanted to ask you, the first is whether you are seeing for your country that tax looks any different. So to the extent you identified a number of sort of concerns broadly in the area of corruption that your tax system would want to tackle to sort of really improve. Are those distinct to taxation? Is there something special about taxation? Or is that something you'd say would be part of an overall sort of government reform or sort of work that you would like to see done? So that's the first question. And the second is, do all the observations that you outlined as connected to the VAT, to the VAT, does that lead you to recommend a different tax? That is, would your tax system be better off moving in a different direction for a while? Or is that not really a solution to some of the problems that you identified?
Thank you, Diana. About the first question, I say that we have the perception we have that the tax system have main and strong relations about criminal law, because the people didn't want to pay the tax. People thinking our government, our public policies is not able to give the people a good life. And the people think that we pay the tax and the public administration use the tax and our money to improve themselves. And this is very, very complicated system. And the people didn't want to pay tax. Okay, so we have in criminal law, the type of the crime to combat this, because we have anti-money laundering law, and our relations with Gafi and FMI and World Bank. We need Angola need to improve our criminal, the type of the criminal, but in fact, the people didn't want to pay our tax. About the VAT, I think we are an oil country, okay? And when the price of the oil go up, the people, our government relax about the tax for the people. And when the price of the oil come down, our government look solution to have more money. And in this thing, we implemented the VAT. And the people see, I think, to simple observation, the people didn't have more confrontation about the VAT. The people say this is the price increment, and Angola is very import very food. We have a big country, but we import all the food. The life of the people must be chaotic about the price of the food basket. And the people say, I did like this VAT. The VAT is, we call some music call, make some music, and they say, the poor just pay VAT. Because the people didn't have capacity to pay. The people is unemployed. Our family is big family, normal. And when the father or the mother did have employment, the people is power, live when $9 per day. It is very complicated, and the VAT is very complicated to us. And but we thinking we need to education the people about the importance of the VAT, and we need to education the public administration how he use the public finance to increment the public policy. Maybe if we can make some justice in this controversial question, maybe the people gain more conscience about this. Thank you.
Thank you, Benja. And that does sort of relate to what I was trying to Poppy about, maybe things being, you gradually will get those improvements you're looking for. Also, I just want to point out, you raised where you actually began your remarks, which was pointing out the nature of the country is both being resource rich, but poor for certain parts of the population, which I think, again, helps us think about the ways in which these are common questions across all countries, but then there are distinct features of each country, each economy that are also going to play into it. And so I thought that was really helpful for you just to remind us of that point as well as we think about it. So thank you.
Okay, thank you. Welcome.
Yeah. Sarah, on to you. Oh my goodness. I had so many thoughts, but we'll just do two. So the first question was, this is sort of narrow, and then it goes from super narrow to enormously big. The super narrow is, why did HMRC sort of effectively give this green light? Was it sort of not, was it a narrow legal inquiry without a sense maybe, or without anticipation of the scope, or something else? And then the second bigger question is, as you look at, UK taxation, and you're talking about the difference between that and Canada, right? Why, if you were to offer, again, just your sense, sort of why is it sitting that way? That is, clearly there are alternatives. And I mean, I actually could imagine you could even debate, you can value anything. I've heard, economists in the USA, you can value anything. I mean, how precise does it have to be? But you can value anything. They could even value my image, right? I think around 0, but they could do it. Right? So you could imagine pushing on that, or you could say, okay, we accept that, but we should need a different regime. So this all goes to your point about reluctance to intervene in sports matters. I loved that sentence. why? So is it the money behind it? Sort of is the politicians' love of it? Sort of your thoughts on why we haven't seen it move? And that kind of gets back to our broader question of the nature of corruption. What leads to systems that may not really be equitable across the board? So narrow and big. To you, Sarah.
I think on the first question, when that case came around, I don't think HMRC had any idea of the implications it was going to bring. Now, if you take that back to 2000, that comes around the time when Premier League is getting massive, sponsorship rights are getting massive. They probably didn't suspect that image rights or endorsement deals would become such a massive thing. It only really came, David Beckham's the perfect example of the most sellable athlete, if you like, but that wasn't always a thing. And I think when they said it, they didn't think it was a massive deal. But what they essentially did was open the floodgates to clubs and advisors saying, right, okay, let's give him 100,000 towards his image instead of paying it in salary, and we can make this massive tax saving. I don't think they quite understood the implications of it when they made the judgment. On the second question, it all comes down to, sport always comes down to money. Everything in sport comes down to money. So, they don't intervene in things like this because they don't want to lose money. And whether we like it or not, the government makes money from holding mega sporting events. They hold money from all these sorts of things, and they don't want to push too hard because they enjoy the reaps of the reward, essentially. But there has to be some other way of doing it, because at the moment, what we have is saying, no, we don't have an image right in UK law, but let's go and make a tax saving based on this image right that ultimately doesn't exist. And it makes absolutely no sense. So there has to be some way of doing it, and Canada do it really well. Obviously, there's moral considerations as to, does Cristiano Ronaldo really need to make a tax saving based on his image? Absolutely not. But, not everyone's a Cristiano Ronaldo. So if we talk about the evolution of female sport at the moment, particularly, women's soccer, these players might get, £3,000 to be in a sponsorship advert. Why shouldn't they be able to make a tax saving on that? So it's not really about, letting your Ronaldos or your Messis make tax savings. It's about making it equitable for everyone, especially, and I think female sport will evolve with that, so that, female footballers aren't on 100 grand a week. They're lucky if they're on £30,000 a year. So why not legitimately make tax savings based upon that?
Thank you, Sarah. We are at 22 past the hour, so I'm going to have to bring this to a close, but I'd like to thank all three of you, Poppy, Benja, and Sarah. It's been really, for me, quite interesting to really start thinking more about these issues, both in really kind of concrete examples, either across countries or fields as well. So thank you all for your participation. Costa, I will turn it back to you.
Thank you very much, Diane, for moderating this panel. Thank you, Poppy, Sarah, and Benja for being with us. And we will now pause again the recording and have the last 10 minutes break, actually 7 minutes sharp, and we will meet again soon for the last panel.